Governor, you know there's a document you have given to us. I'm sure you have capacity to read, because we are not going to listen to what people think in their minds for now. There's a document that you have tabled before this House. That is the document we are going to rely on. So I would kindly ask that you proceed to make responses as the Governor of Nakuru.
No problem, Chair. So this is a response to statements on the closure of Nakuru War Memorial Hospital. And so we are referring to that matter, and we have given the documents and attachments, and I will proceed to read our response. The Constitution of Kenya is hailed as one of the most transformative among the normative provisions that form the basic structure of the devolved governance system. Under the scheme of devolution, there is a vestiture of functions which cannot be argued against, and that health functions are vested in county government. The fourth schedule of the Constitution on distribution of functions between the national and county government states as follows on the role of the county government. County health services, including in particular county health facilities and pharmacies, ambulance services, licensing and control of undertakings that sell food to the public, veterinary services, excluding regulation of the profession, cemeteries, funeral parlors, and crematoria, and refuse removal, refuse dumps, and solid waste disposal. The fact that the improvement of healthcare is an important and critical consideration is not in dispute. The Constitution itself lists the right to healthcare services as part of every person's right to the highest attainable standards of health. It is the first of the economic and social rights listed in Article 43 of the Constitution. Article 21(1) of the Constitution also provides that it is a fundamental duty of the state and every state organ to observe, respect, protect, promote, and fulfill the rights and fundamental freedoms in the Bill of Rights. In this regard, the obligations of the state and its organs are clear-cut. It must observe, respect, protect, promote, fulfill the rights and fundamental freedoms in the Bill of Rights. The very raison of the state is the welfare of the people and the protection of the people's rights, and it is the obligation under international and national laws to ensure that human rights are observed, respected, and fulfilled, not only by itself, but also by other actors in the country. The county government is duty-bound by law to ensure the defense of the Constitution and the constitutional obligations stemming from their oath of office. It is on this basis that the Nakuru County government set out to defend the Nakuru War Memorial Hospital from illegal acquisition by private entities. Factual background. By way of a background, the Nakuru War Memorial Hospital was under the directorship of a trust comprised of 9 directors, including the provincial medical officer and the provincial commissioner, to safeguard public interest in the land and the running of the health facility sitting therein. The current directorship of the hospital is 5 directors, excluding the 2 government representatives who were kicked out under unclear circumstances. And you may refer to the marked NCG, that's Nakuru County Government 1A, and NCG 1B is a copy of the current directorship of Nakuru War Memorial Hospital Limited as compared to the initial one of the Nakuru War Memorial Hospital Trust. As early as 2019, even before the current leadership of the County Assembly of Nakuru had already considered the state of Nakuru War Memorial Hospital and the Rift Valley General Hospital Annex, and recommendations for reversion of the hospital to the county government were passed at the County Assembly of Nakuru. The deliberations of the County Assembly are reported as follows on 11th June 2019. War veterans. Nakuru War Memorial Hospital is under private ownership and the county government should move fast and revert the land to the county government, said Dr. Bai. Dr. Bai said the Nakuru War Memorial Hospital was established to take care of the veterans of the First and Second World Wars. The land at which Nakuru War Memorial Hospital sits on ought to have been reverted to the government. The facility should be managed by the County Level 5 Hospital, said Dr. Bai. The Assembly Health Report paints a sorry state of the Annex Hospital. The security of patients and the facility is not assured as the hospital has no permanent perimeter wall, said the report. The report further revealed that the hospital's only ambulance is in poor condition and the patients are referred to the Nakuru Level 5 Hospital for emergency cases. On the 9th of January 2020, Nakuru War Memorial Hospital, through Naku Plan Consultants, applied for an extension of lease to the county government. Now shown as exhibit or marked as NCG2 is a copy of the said application and accompanying report by the consultants. Okay. Yeah, you're right. Okay. Oh, we doesn't have page number. Okay. Okay. Oh, it actually has a page. I'm sorry. So page 21. Sorry, looking for me. The page.
Proceed, Governor.
Oh, thank you, Chair. Sorry, and I'll keep pointing to the pages now. Okay, so as shown on page marked as NCG2, which is page 21, is a copy of the said application and accompanying report by the consultants. In the application, the consultant noted that there exists Provincial General Hospital, the PGH, annex on the same land. The sub-county planner, Collins Ogola, noted that there is an existing tussle between War Memorial Hospital and PGH annex on the same parcel of land and therefore advised that the same be first addressed. Now shown to me, they are marked NCG3, which is page 37, is a copy of the letter by the physical planner. Subsequently, the Director, Land and Physical Planning wrote to Naku Plan inviting them to a discussion, but on 14th February 2023, Naku Plan wrote back to say that instructions to pursue the plan were withdrawn by War Memorial and therefore the request for extension stands withdrawn. And that is marked as NCG4, which is page 38 and 39, and it's a copy of the said letter dated 14th February 2023. On 15th March 2022, the County Secretary of Nakuru wrote to the Chairman, National Land Commission, requesting that the land be set aside for the county government to develop specialized medical services. And that is marked as NCG5, which is page 41. 41 and 42 is a copy of the letter to the chairperson of the National Land Commission. On the 27th of March 2023, the sub-county planner noted that there was an illegal construction going on the land and alerted the county director for physical and land use planning. A stay order was issued on the same by the Director Land and Physical Planning. That's marked as NCG6, which is page 44 and 45, a copy of the said letter dated 27th March 2023, and NCG7, that is the 44 and 45, yeah. Sorry, that is page 46, I'm sorry, is a copy of the said stay order. On 28th March 2023,
Homogeny is 47. Yes. And you're going to have your fingers on the annexes and the other ones on the... Proceed, Governor.
Thank you, Chair. Okay. Sorry. On the 28th of March 2023, the County Executive Committee member for Lands, Physical Planning, and Housing and Urban Development wrote to the Registrar of Lands requesting for certified copies of the green and white card for Nakuru Municipality Block 11/107. And it is marked as NCG 8, page 49, and it is the said letter that was dated 28th of March 2023. On the 6th of April 2023, and let me point out there's a typo there or an error. It's not the Nakuru War Memorial Hospital Limited, but the registrar. The registrar wrote to the County Executive Committee member for Land and Physical Planning, Housing and Urban Development, forwarding the certified copies of the green card and the white card. And this is marked as NCG 9, which is page 51 to 53. So 51, 52, and 53. A copy of the said letter dated 6th April 2023. On the 30th of March 2023, the County Director, Land and Physical Planning, wrote to Nakuru War Memorial Hospital informing them of the stay order and the need to seek necessary approvals. In response, the developer produced a purported approved plan and payment receipts, which on examination turned to be forgeries. And that is marked as NCG 10, which is page 55. It's a copy of the said letter dated 30th March, and NCG 11, a copy of the said receipt, which is on page 57. The developer also produced an extension of lease, which the county government was not aware of, with the application for extension of the lease abandoned. And this is shown as NCG 12, which is page 60, 61, 62 and 3, 62, 3, 4, 5, up to 65. That is a copy of the said list, sorry. On the 6th of April 2023, the County Secretary wrote to the Registrar of Lands, Nakuru, complaining about the illegal extension lease and requesting that the same be cancelled and the land be reserved for Nakuru County Provincial Hospital Annex. And that is shown as NCG 13, which is page 67 and 68, which is a copy of my letter to the land registrar. Sorry, a copy of the letter by the County Secretary to the land registrar. The Nakuru Land Registrar, through Gazette Notice 6309, dated 19th May 2023, cancelled the lease, citing an erroneous issuance process. Upon the cancellation of the lease that was acquired fraudulently, the county government took upon itself to take over the hospital, noting that there was an earlier consideration of this issue by the County Assembly of Nakuru and a report to effect prepared. On the 27th of October 2023, the county government took over the hospital upon discovering a scheme by an illicit consortium of individuals who had made underhand plans characterized by falsification of documents with the aim of privatizing public property and selfishly seeking personal gains from public property. The takeover was peaceful. The county government deployed its medical staff to maintain the operations of the hospital while dealing with the patients that required attention during the transition period. Needless to state, Nakuru County government, being the constitutional citadel on matters health per the forged schedule of the Constitution, in ensuring that the interests of the citizens of Nakuru are upheld, exercised its constitutional mandate in ensuring that the said hospital is managed for the benefit of the people of Nakuru County. The court process. a plaint and notice of motion dated and filed on 30th October 2023, Nakuru War Memorial Hospital Limited approached the Environment and Land Court decrying the taking over of the management of the Nakuru War Memorial Hospital by the county. And that is Nakuru ELC number 36 of 2023, Nakuru War Memorial Limited versus Nakuru County Government and two others. The trial court in a contentious land matter issued an interim ex parte order on 31st October 2023, which we reproduce herein. Upon reading of the application together with the supporting affidavit, a temporary injunction is hereby issued restraining the defendants, respondents, their employees, servants, and/or agents from further dealing, entering, remaining, and carrying out other unauthorized activities on the plaintiff's applicant's land, known as Nakuru Municipality Block 11/107, measuring 11.25 hectares, and in particular, any interference whatsoever with the running, operation, and activities of Nakuru War Memorial Hospital and facilities. And that is marked as NCG 14, which is page 70, and a copy of the said ex parte order. The land court purported to issue orders that particularly affect the running and operations of a health facility which jurisdictional mandate is not recognized in Section 13 of the Environment and Land Court Act. The county government filed an application to court dated 2nd November 2023 that sought the following order: that this honorable court be pleased to vacate, discharge, and/or set aside the interim orders of injunction dated 31st October 2023. The court did not consider the application despite being filed under certificate of urgency. Later on, the county government was served with a further order of 2nd November 2023, which stated as follows: an order is hereby issued directing the Sub-County Police Commander Officer, the former OCPD, Nakuru Town East Sub-County, to assist the plaintiff applicants in enforcing the orders of this court dated 31/10/2023 to allow access to Nakuru War Memorial Hospital. The court had considered another application by Nakuru War Memorial Hospital Limited and gave orders instantly while rejecting the county's application. Further, the court gained ex parte orders on a land matter that resulted in the eviction of county government from the hospital without hearing the county government. And that is marked as NCG 15, a copy of the said ex parte order, and that is page 72. On the wake of this revelation, the county government filed yet another application on the 6th of November 2023 seeking the following orders: that this application be certified as urgent and be heard ex parte in the first instance. That this honorable court be pleased to issue an interim stay of its orders dated 2nd November 2022 pending the hearing and determination of this application. That this honorable court be pleased to issue an interim stay of its orders dated 31st October 2023 pending the hearing and determination of this application and the first defendant / applicant's motion dated 2nd November 2023. The Honorable Court be pleased to set aside its orders dated 31st October 2023 and 2nd November 2023 respectively upon hearing the determination of this application and the first defendant's motion dated 2nd November 2023. This Honorable Court be pleased to issue a temporary order of injunction restraining the plaintiff, a first respondent, from interfering with the peaceful takeover and running operations and activities of Nakuru War Memorial Hospital situated in the land known as Nakuru Municipality Block 11/107, which the applicant holds as public land in trust for the residents of Nakuru County pending the hearing and determination of this application. This Honorable Court be pleased to issue a permanent order of injunction restraining the plaintiff or first respondent from interfering with the peaceful takeover and running operations and activities of Nakuru War Memorial Hospital situated in the land known as Nakuru Municipality Block 11/107, which the applicant holds as public land in trust of the residents of Nakuru County upon hearing and determination of this application. The costs for the application be provided for. The court failed to hear and determine this case despite the county government filing 2 applications dated 2nd November and 6th November 2023 for setting aside the ex parte orders due to material non-disclosure, deception, misrepresentation, and non-disclosure of material facts. The county government is yet to be accorded the right to be heard to date. It is apparent that the ex parte orders were granted on the basis of forged certificates of lease. On 22nd of January 2023, on 22nd January 2024, my apologies, Chair and members. So on 22nd January 2024, the Office of the Director of Public Prosecution preferred charges against, inter alia, directors of Nakuru War Memorial Hospital Limited before a Nakuru magistrate with 12 counts related to abuse of office, forgery, and conspiracy to defraud in Nakuru, MCCR/E 153/2024, Republic versus Simon Watene, Roger Jocelyn, and 3 others. On the 19th of January 2024, the county government of Nakuru learned that the War Memorial Hospital directors had been arrested and not granted bail. Following uncertainty of the patient's safety and continuity of care, the county government on the 23rd of January 2023 issued an advisory to the public asking relatives to consider transferring their patients to other facilities. I'm so sorry, on 23rd January 2024. Sorry, let it reflect, it's not 2023. So issued an advisory to the public asking relatives to consider transferring their patients to other facilities. Relatives visiting their patients were informed that the directors of the War Memorial Hospital had been arrested, and they were advised to transfer their patients in consultation with their doctors as there was a lacuna in management. On the 23rd of January 2024, again I apologize, it's not 2023, the court ordered a site visit to the hospital and thereafter ordered the police commander, Nakuru County, to return the War Memorial Hospital leadership back to the hospital. That is marked as NCG 17, a copy, which is page 74, is a copy of the said orders of 30th January 2024 and 2nd February 2024. Sorry, so it's page 74 and 75. The Environment and Land Court has since then overstepped its mandate and presently seeks to hold the county in contempt on account of management and control of the hospital, which is not a matter within the specific jurisdiction of the Environment and Land Court. In Dixon Gige Ngoge versus Commissioner of Lands, SC petition number 9 of 2019, the Supreme Court made a binding finding that jurisdiction goes to the root of any cause or dispute before a court of law. A court must exercise restraint to avoid overstepping its constitutional role in order to maintain its legitimacy. If a court has no jurisdiction, a judgment rendered therein does not adjudicate the dispute. It does not bind the parties, nor can it be made the foundation of any right. It is a nullity within life or authority. In short, it is coram non judice and amounts to a nullity because, as Nyarangi J.A. famously said in the Locus Classicus, owners of the motor vessel Lillian S. versus Caltex L, Kenya, Limited, 1989, jurisdiction is everything. The Environment and Land Court has since denied the county audience, while the accused persons continue to enjoy orders that exceed the mandate of the court at the expense of the county government. The conduct of the entirety of the trial process has been oppressive to the county, with threats of being found in contempt being thrown at them periodically, while the land grabbers enjoy per incuriam court orders unworthily. In essence, the trial court, in acting without jurisdiction, has inflicted a total breakdown in the management of Nakuru War Memorial Hospital. Interestingly, the court is yet to deal with the merits of the case which question the validity of the renewed lease by purportedly owned by the private entity. Further, the same court, in a separate case by the Nakuru War Memorial Hospital Limited, to wit, Nakuru ELC JR 7 of 2023, Nakuru War Memorial Hospital Limited versus Land Registrar, Nakuru County and the Attorney General, has issued orders for stay of the cancellation of the lease, demonstrating a well-orchestrated plan to rubber stamp the illegalities of the directors of Nakuru War Memorial Hospital by use of court orders. The county government has since preferred an appeal to the Court of Appeal in civil appeal application number E015 of 2024, Nakuru County Government versus Nakuru War Memorial Limited and two others, seeking the following orders. That this honorable court be pleased to certify this application urgent and hear it ex parte at the first instance. That this honorable court be pleased to stay any further proceedings in Nakuru ELC 36 of 2023, Nakuru War Memorial Limited versus the county government of Nakuru and two others, pending the hearing and determination of this application. That this honorable court be pleased to stay any further proceedings in Nakuru ELC 36 of 2023, Nakuru War Memorial Limited versus the county government of Nakuru and two others, pending the hearing and determination of the intended appeal. That this honorable court be pleased to issue a temporary injunction to prevent the first respondent from exercising control and management of Nakuru War Memorial Hospital, pending the hearing and determination of that application. That the honorable court be pleased to issue a temporary injunction to prevent the first respondent from exercising control and management of Nakuru War Memorial Hospital, pending the hearing and determination of the intended appeal. That the cost of and incidental to this application be in the cause. As it stands, the management of Nakuru War Memorial Hospital has been taken over by Nakuru War Memorial Hospital Limited. The criminal nature of the circumstances surrounding the renewal of the Nakuru War Memorial lease. The criminal nature of the process that resulted in the renewal of the lease for Nakuru Municipality Block 1107 has been a matter of national notoriety and will be demonstrated by two limbs in this report inter alia. A summary of the criminal charges levied against the directors of Nakuru War Memorial Hospital Limited in MCCR E152 2024. R versus Simon Mwangi Watene, Roger Jocelyn, Kemboi Marindich Kigen, Peter Zuki Mutuiwa, and Stephen Kihenjo Omwaura Kigen, and an illustration of the spurious nature of the certificate of lease provided. In MCCR E152 2024, as read above, the defendants, being the directors of Nakuru War Memorial Hospital Limited, are facing 23 counts of offenses related to the renewal of the lease for Nakuru Municipality Block 11/07 inter alia. Fraudulently procuring of the registration of a document contrary to Section 157(1)(c)(1) of the Land Registration Act number 6 of 2012, premised on the following particulars: that the accused persons on the 7th day of April 2021 at the Ministry of Lands, Athi House, Nairobi, within the Republic of Kenya, jointly with others not before court, procured the extension of lease for 50 years. In respect to parcel of land registration number Nakuru Municipality Block 11/107, which led to the issuance of a certificate of lease to Nakuru War Memorial Hospital Limited. B. Forgery contrary to Section 349 of the Penal Code, with the particulars being that Simon Mwangi Watene, Roger Jocelyn, and Kemboi Marindich Kigen, on a known date, time and place, within the Republic of Kenya, jointly with others not before court, with intent to defraud forged a signature of Robert Otiti in a document, namely proposed extension of lease of Nakuru Municipality Block 11107, purporting that the said document originated from the Ministry of Lands, Provincial Surveyor's Office, Rift Valley, and signed by the said Robert Otiti, a fact they knew to be false or untrue. C, making a document without authority contrary to Section 357A of the Penal Code, with the particulars being Simon Mwangi Watene, Roger Jocelyn, and Kemboi Marindech Kigen on a known date, time, and place within the Republic of Kenya, jointly with others, not before the court, with the intent to defraud without lawful authority, made a document, namely proposed extension of lease Nakuru Municipality Block 11/107, reference SK PDP NKU MUN Volume 4 110, purporting that the said document originating from the Ministry of Lands, Provincial Surveyor Office, Rift Valley, a fact they knew to be false or untrue. Altering a false document contrary to Section 353 of the Penal Code, with the particulars being that Simon Mwangi Watene, Roger Jocelyn, Kipkemboi Kigen on a known date, time, and place within the Republic of Kenya, jointly with others not before the court, knowingly and fraudulently, uttered a forged document, namely proposed extension of lease Nakuru Municipality Block 11/107. Again, the reference SK PDP NKU MUN Volume 4 110, purporting that the said document originated from the Ministry of Lands, Provincial Surveyor Office, Rift Valley, a fact they knew to be false or untrue. And this is marked as NCG 18, which is page 77 to 89, a copy of the charge sheet. From the foregoing, it is apparent that the criminal liability of the directors of Nakuru War Memorial Hospital Limited is clearly underscored by a preponderance of evidence that not only satisfies the evidentiary test under 4B1 and 2 of the National Prosecution Policy to enable the Office of the Director of Public Prosecution to prefer the said charges, but would also attract a guilty verdict before any sober tribunal. Further, the fraudulent scheme to obtain the renewed certificate of lease is so obvious that its fraudulent nature screams at the very sight of the purported renewed certificate of lease issued on the 23rd of April 2021 and the accompanying documents as demonstrated below. The green card accompanying the purported renewed certificate of lease does not contain the requisite registrar's signature. There is no evidence or record of any approved application for extension of lease on the suit property that culminated to the purported renewed certificate of lease. The only application for extension of lease was withdrawn before approval was given due to the existence of a dispute between the hospital and the PGH. And 4, there are ongoing prosecutions with regard to the authenticity of the impugned certificate of lease. E, the closure of Nakuru War Memorial and transfer of patients. The closure of the Nakuru War Memorial Hospital is not attributable to the county government, despite sharp disagreements with the conduct of the court process and orders ensuing therefrom. The county government has endeavored to obey the court's orders nonetheless. Upon learning about the illegal scheme of taking over government land that hosts the Nakuru War Memorial Hospital, the county government took over the hospital on the 27th of October 2023. The management of Nakuru War Memorial Hospital, in its application to the court dated 30th October 2023, pleaded as follows: that the first defendant or respondent, Nakuru County Government, goons forcefully discharged and chased away all patients who had been admitted at the hospital, as well as those receiving outpatient services, together with all staff working at the hospital at the time. These unfounded assertions are the most likely cause of the request for this response. We respond to the questions of transfers in the following unequivocal terms. The county government, through itself, its agents, and or assigns, did not transfer any patient from Nakuru War Memorial Hospital. There exists no discharge summary to this effect, and this was not a line pursued by the county government of Nakuru. The county government is aware of patients that were discharged by their own doctors on account of either recuperating or referral to other facilities without recourse to the county government. The county government is equally aware of patients who, on account of the tension on the issue of ownership of the War Memorial Hospital, chose to be admitted at the Nakuru Provincial General Hospital Annex, which is in the same building with Nakuru War Memorial. Upon such a decision being made, the county government took charge and responsibility of these patients in fulfilling its constitutional mandate on the right to health. The proximity of the Nakuru War Memorial Hospital to Nakuru PGH Annex is equally highlighted to this house, as the two facilities are essentially within the same building. A transfer from one facility to the other is ordinarily seamless, achievable in a question of minutes, and the suggestion that such a transfer would have violated a patient's rights is inflammatory and is motivated by malice. The court ordered on 2nd November 2023 as follows. An order is hereby issued directing the Sub-County Police Commander Officer, the former OCPD, Nakuru Town East Sub-County, to assist the plaintiff or applicants in enforcing the orders of this court dated 31st of October 2023 to allow access to Nakuru War Memorial Hospital. Upon service of this order, the county handed over the operations of the hospital to the management of Nakuru War Memorial, despite being aware that their management is by an illegal and corrupt scheme just to be compliant with court orders. Since the 2nd of November 2023, the Nakuru government has not been in control of the hospital and can therefore not give an account on the issue of its closure. In any case, the said closure is against the mandate of the county government in providing access to services, to health services to the people of Nakuru. The court gave repetitive orders to ensure that the county government is kept away from taking over the hospital. By its orders dated 30th January 2024 and 1st February 2024, the court ordered the county police commander to ensure that the hospital is run by the management of Nakuru War Memorial Hospital, to the exclusion of the county government. This presents the reigning position at this moment, despite being unfortunate that hospital is in the hands of private individuals who are seeking personal benefits by attempting to alienate public land. It is worth noting that this land was reserved for specialized health infrastructure and medical tourism through build, operate, and transfer partnership for the benefit of the people of Nakuru, and as it stands, this project cannot see fruition. Lastly, on the question of compensation, no party in law can gather reparations flowing from an illegality. There are no plans whatsoever for the compensation of the people illegally managing Nakuru War Memorial. In fact, compensation should flow from them to the county government of Nakuru. Be that as it may, this issue will abide by the courts. We will abide by the court's outcome and still present that it is sub judice. So we still continue to hold that objection. In conclusion, we are immensely grateful for this opportunity by the Senate to clarify issues that pertain to the healthcare of Nakuru County government. As the House that is mandated with championing for devolution and ensuring that the devolved units are running properly, we implore you to weigh in on this issue to ensure that sanity is maintained and the courts are measured in issuing orders that have consequential effects on critical functions of the counties. This response represents the actual situation that is plaguing the management of the Nakuru War Memorial, that is currently in the hands of the illegal management company of private individuals. Nakuru County is committed to ensuring that every person in the county has access to the highest attainable standard of health, which includes the right to healthcare services, including reproductive healthcare as espoused virtually hook, line, and sinker in Article 43 of the Constitution of Kenya, 2010. Thank you, Chair. I submit.